All right, hi, can everyone hear me? Hopefully. This is Hina Mansouri, Managing Attorney of the Detention Project at National Immigrant Justice Center. I'm here with my colleague Lupe.
Hi everyone, this is Lupe Perez. I'm a supervising attorney with the Detention Project.
And today we are doing this webinar as part of our Access to Justice grant to provide trainings on detained representation. We are doing this webinar regarding how to prepare cancellation cases. Just an overview of NIJC for those of you who aren't as familiar with us. Our main office is in the Loop, but we have other offices as well. And through A2J, we are both taking on cases, both detained and non-detained, and we are also providing trainings and also putting together a manual regarding representation of detained individuals. And hopefully we'll have that manual completed within the next month and be able to get that to you all. So the agenda for today is basically to go over the three primary forms of cancellation that we deal with. And then we're going to leave some time at the end for question and answer. So if folks want to go ahead and if you have questions during the presentation, go ahead and just put them in the question box. But we are not going to stop and respond to those questions until the end, but we will look at them then and try to get to what we can at the end of the presentation. Additionally, we're going to try, we have some hypotheticals in here, and we're going to try to get folks to respond via the chat box. Everyone is muted, so you won't be able to talk, but if you put your responses in the chat box, we'll look there and see how people are responding. Okay. And now we're going to go ahead and start with the actual training. An overview of cancellation of removal. So cancellation is a form of relief that is only available to individuals who are appearing before the immigration court, either in deportation proceedings for folks who were put in proceedings a long time ago, or current day removal proceedings. So individuals cannot affirmatively apply for cancellation. With cancellation, if it's LPR cancellation, somebody already is an LPR with a green card. If they are granted cancellation, they will keep their green card. For other individuals who are undocumented, by receiving cancellation of removal, they also automatically have their status adjusted to LPR status. And so this is like a really strong remedy for individuals who do qualify and have cases, because it's a way for an individual who's undocumented to apply before the court for LPR status and to be able to get that LPR status without having to go through USCIS, without regard to the fact that they entered without inspection. So for folks who do have strong cases with respect to hardship or as victims of domestic violence, this can be a really good remedy for them. Cancellation is something that you can only get once. So once somebody has applied for one form of cancellation, they cannot get it another time. And this is a very important point, especially for lawful permanent residents. If an LPR obtains LPR cancellation, or also if they have received 212C, the former version of LPR cancellation in the past, they are not able to, again, apply for LPR cancellation if they have another offense that makes them deportable. And this is something that we advise our clients time and time again, but unfortunately we do sometimes see that individuals get convicted again of new offenses. Yeah, I just realized that I have not properly shared the slideshow, so give me 1 second. This is my first time trying this software out. Okay. Okay, so folks should now be able to see the slide with the overview of the different types of cancellation. Sorry about that. There are 4 types of cancellation. Today we're going to be talking about the first 3 types: LPR cancellation, non-LPR cancellation, sometimes known as 10-year cancellation or hardship cancellation, and VAWA cancellation. NACARA cancellation is pretty rare these days, so we're not going to talk about that today. Cancellation cases, when somebody is detained, can happen fairly quickly. It's the same time frame as for filing any other application in the detain court, where it can generally be resolved, at least before the Chicago court, within 3 to 5 months. And sometimes it can be even quicker if the person is ready to go with their first semester calendar and submit an application. And non-detained court, it of course all just depends on the backlog of the courts. It's discretionary relief, and again, the approval rate just will vary greatly among judges. Some judges are more understanding, for example, for LPR cancellation of individuals with crimes, while others are not. So a lot will depend on knowing your judge. Okay, so just an overview of the requirements for these 3 types of cancellation. First of all, for LPR cancellation, you have to have at least 7 years in the US following your admission without committing certain crimes, 5 years as an LPR, no aggravated felonies, and then of course a discretionary element. For non-LPR cancellation, you have to have been living in the US for at least 10 years, have qualifying family members, and establish exceptional and extremely unusual hardship to those family members. So there are several additional requirements for non-LPR cancellation in terms of family and hardship that aren't present otherwise. And then for VAWA cancellation, you have to establish that you have been battered or subject to extreme cruelty by a US citizen or LPR, and that you have 3 years continuously residing in the US without certain crimes, and you have to establish extreme hardship to yourself or to your family. And we're going to break all of these down now. Okay, so I'm going to talk about LPR cancellation in more detail now, and then once I'm through with this, Lupe is going to talk about non-LPR cancellation and VAWA cancellation. So LPR cancellation, again, is a discretionary waiver for lawful permanent residents who become deportable, most frequently due to criminal convictions, though sometimes it can be another ground. To qualify for LPR cancellation, the applicant has to have been an LPR for at least 5 years, have resided in the US continuously for 7 years after having been admitted in any status, not have an aggravated felony, and merit cancellation in the exercise of discretion. The 5-year element begins with the date of admission as an LPR to the US. And note that for some folks who enter the US as LPRs, it will be that date. For other folks, it'll be a later date if they adjusted within the US. Another important thing to know is that this 5 years requirement is not subject to the stop time rule. So that means that somebody could commit crimes, could be placed in proceedings, and the 5 years will keep running. That probably makes a bigger difference for folks in non-detained proceedings than it does for folks in detained proceedings, who it's really, really only of note if they're going to reach that 5 years a couple of months into their proceedings. But it is something to keep in mind that 5 years does keep on running. The 7 years is a little bit trickier, and there has been a fair amount of litigation as to when the 7 years starts and when the 7 years ends. First of all, it's important to know that the 7 years does not start with any entry into the United States. So if someone enters without inspection, or if they are paroled into the US, that does not start to 7 years. It has to be a lawful admission. However, it need not be that the person stay in that status. So for example, somebody could enter the United States on a student visa, fall out of status, later on adjust their status to LPR, and that date that they entered on the student visa, so long as they have remained in the US since that entry, would count as the date beginning the 7 years. The 7 years is subject to the stop time rule, and when the clock stops is the subject of a quite recent Supreme Court decision, the Barton v. Barr decision, that some of you guys may have seen. And we're going to break that down a little bit as to what that means. So what the Supreme Court said in Barton is that the 7-year period stops whenever an LPR commits an act under INA 212A2, which are the criminal grounds of inadmissibility. What folks were arguing was that a 212A2 offense should not stop the time for an LPR if that 212 offense did not also render the LPR inadmissible. The argument being that an LPR has already been admitted and therefore cannot be rendered inadmissible. The Supreme Court in this decision by Justice Kavanaugh, however, sided with the government and said that any 212A2 offense, so any of those criminal grounds of inadmissibility, for those of you who attended Diana and Lupe's presentation back in March, going over those, like any of those offenses, even if that offense does not actually make the LPR deportable, that does cut off their time for LPR cancellation. I know it gets a little bit tricky. If folks have questions about that, please feel free to leave questions in the question box. But the bottom line, unfortunately, due to the Barton decision is, before we were able to make some arguments that if it was an offense that was only under 212A2, and there are some offenses that are under 212A2, but not under 237A2. For example, the petty offense marijuana, or potentially one crime involving moral turpitude that's not petty offense exception, but would be outside of 5 years of admission. Those things are now going to cut off time for LPRs, even though they are not making them deportable. Okay, we're gonna move on to a hypothetical. For those of you who have little kids at home, hopefully you'll identify a little bit with this fact pattern. I'm gonna go ahead and let folks read it and then invite individuals to kind of try to put their thoughts in the chat box. I'm gonna give folks about 2 minutes to do that. So we're trying to figure out if Ernie here, who's an LPR through his marriage to Bert, is eligible for LPR cancellation despite his criminal record. So I'm not seeing any responses in here. I don't know if it's working for folks or not. So let's go ahead and talk this through. So Ernie here entered the US on a B1 visa in 1999. In 2000, he married Bert, and in 2001, he became an LPR. So Ernie's time, so first question is, does he have the 5 years as an LPR? He became an LPR in 2001. It's now 2020. Yes, he has the 5 years. The next question is, does he have the 7 years? And this is the part that's a little bit trickier, right? So the time starts with his entry on the B1 visa in 1999, right? But when does the time stop? The time stops, according to the Supreme Court in Barton, whenever he has an offense under 212A2, even if that offense does not separately make him removable. So if you look at this hypothetical, Ernie in 2005 was arrested for possession of less than 2.5 grams of marijuana. That is an offense under 212A2. Even though there's a petty offense exception for marijuana under 30 grams for personal use under the 237 grounds of deportability, there is no equivalent exception under the 212A2 grounds, and therefore this 2005 commission of possession of marijuana, for which he pleaded guilty, unfortunately does stop his time for LPR cancellation. Since Ernie entered in 1999 and he had this offense in 2005, he triggers the stop time rule with the marijuana possession 6 years after his entry. Now keep in mind that if Ernie hadn't committed any additional crimes, and if he stayed in the US, he wouldn't be deportable just because of that marijuana possession. But because Ernie did later on get convicted of these 2 retail thefts, which would be crimes involving moral turpitude, at least under the Illinois statute, retail theft statute, those do make him deportable. And with the combination of those offenses and that 2005 possession, unfortunately, he's both deportable but not eligible for LPR cancellation. So this hypothetical is meant to show how you can have dire consequences even for a pretty minor violation soon after arriving in the US, contrary to the way that Justice Kavanaugh frames his decision in Barton as applying only to individuals with serious criminal records. It can also affect folks with pretty minor records as well. Okay, and we're going to move on to the third element for LPR cancellation, and that is that you cannot have an aggravated felony. Again, refer to INA 101A43 for the aggravated felony definition, as well as to our presentation from March 20th on immigration. Note that if somebody does have if an LPR does have an aggravated felony, but it's a very old aggravated felony, that occurred before April 1st, 1997, that person potentially could still be eligible for 212C relief. So keep that in mind as a possibility for folks who do have old convictions. But an aggravated felony will definitively make somebody ineligible for LPR cancellation. Okay, and then the fourth element is the merits positive discretion. And this is where most of your case prep is going to be focused. Once you've gotten past eligibility, generally for a detained cancellation case, DHS, unless there is a stop time issue, DHS isn't going to, or an aggravated felony issue, DHS isn't going to spend a whole lot of time arguing against statutory eligibility, and instead they're going to focus their attention on trying to show that your client does not merit a positive exercise of discretion. So it's a balancing test, right? It's a test that's laid out in these 2 cases, matter of Marin and matter of CVT, where you want to show that the positives in your case outweigh the negatives. And of course, things like having a long history in the US, particularly since a young age, school employment history, lots of family ties, and being able to show remorse and rehabilitation for criminal history can weigh in your favor. Whereas, of course, your criminal record, being dishonest, not taking responsibility, other bad behavior, not paying child support, not paying taxes, things like that would be negative factors that would weigh against an applicant. So your job as a representative is to show that the positives outweigh the negatives. And even where certain negatives still do exist, try to show that your client is going to rehabilitate himself so that those negative factors diminish in the future. Okay, so we're moving on to another hypothetical. Alex here entered the US in 2000 with a B1, B2 visa. His wife petitioned for him and he became an LPR in 2007. He has a possession of marijuana and a possession of cocaine. He has several DUIs. His parents are LPRs. He has a 3-year-old son who is in speech therapy. And Alex is luckily eligible for LPR cancellation despite his criminal record. He's been an LPR for more than 5 years. He does not trigger the stop time rule within 7 years because his first 212 offense is in 2009 and he entered in 2000. And he has some family ties, obviously. He's been here for a long time. What are some of the things that you would want, otherwise, that you would want to explore with Alex? What are some of the positive factors you would want to draw out, and what are the negative factors, and how would you want to address those? And if anyone wants to try to take a shot at putting any responses in the chat box. I can also try calling on people if I unmute them and see. I don't know if I want to put people on the spot in recording though, so maybe I won't do that. But if anyone wants to volunteer, and for some things that they think are relevant. Oh look, someone's. So let's see. Lupe's put some suggestions in here. Okay, looks like those are coming from a couple of our staff members. Okay, so yeah, some of the things that folks have put down are exploring his relationship with his family, his work history, his length of time in the US, to put forth positive factors. Negatives, of course, would be his drug use, his substance use, exploring whether he has sought any rehabilitation or has plans to seek rehabilitation in the future. Definitely addressing those possession charges would be important. Getting more information about his son's speech therapy, what his son's needs are, getting medical documents about the son's speech and language issues. And I think, seeing whether he's involved in his son's speech therapy. If the last DUI was in 2000, has he rehabilitated? And is there any proof of that? Yeah, those are all good suggestions. So it looks like some of those are coming from a few NIJC staffers, as well as from Jean as well. So thanks so much, guys, for those suggestions. Those are all definitely things that you would want to explore. Definitely for any time you have somebody with substance abuse issues, exploring whether the person has sought rehabilitation, and if not, why not, and what's changed now that will lead to them actually seeking rehabilitation in the future is huge. A lot of times folks have trouble admitting to substance abuse, particularly where they've hid it from family members and others for a long time. So you may be the first person to be able to break through to them and get them to understand that they do have a problem that needs to be addressed. And that is a role that we take, even as being attorneys and not social workers. We do take that role a lot, particularly for clients with addiction issues and criminal records, to explore those things with them, and show how they can make positive changes in the future. Okay, so now on to some of the practical advice. You are going to want to submit the application form, the EOIR 42A, in court. So you would be appearing in detained court. You would be pleading to the NTA and admitting that your client is deportable, and then filing the 42A form. The form is largely biographical information with a series of yes or no questions as well. You want to fill it out to the best of your ability, but don't stress over it too much. Lots of folks who are detained have trouble remembering exact addresses, things like that. You do want to make sure that you add addenda for information that doesn't fit on the form. I would suggest creating a criminal chart as laid out in the Immigration Practice Manual. There's a sample on your materials as well. You either want to feed in to the Texas Service Center or you want to get a fee waiver grant from the judge for the $185 fee, $100 for the application plus $85 biometrics, so that the IJ can adjudicate that application without there being any issues in the future. And then you want to put together a short pre-hearing brief. Generally, our LPR cancellation briefs are between like 7 to 10 pages, nothing super long. And you want to make sure that you're emphasizing the positive discretionary factors and how those outweigh the negatives. You also want to put together an index of supporting documents. You always want to have an affidavit from your client where your client is able to explain both the positives and also be upfront about the negatives and show how they are rehabilitated. And then you want to include all other discretionary evidence as is possible. Try to get letters of support or affidavits, definitely at least from close family members, and if possible from friends, church, employers, etc. For folks with substance abuse, again, evidence of rehabilitation or plans to get rehabilitation are crucial. Anything else that you can gather to show that the person has overall been a good person here in the US is what you want to put together for your packet. And then at the hearing, you of course want to make sure that your client is prepared to testify truthfully and show that they deserve another chance. Your case will always backfire if your client decides to lie in court. And it will always hurt your client if he makes excuses for his criminal conduct. This is something that you have to work with your client on, you know, coming out of, you know, somebody who's been through criminal court. It's obviously very different where the person is presumed innocent until found guilty. In immigration court, the judge, you know, when the person already has a conviction, even if it was an unfair conviction, is going to look at the criminal act as having happened, and you are going to want to prepare your client to be able to address their record and, you know, show rehabilitation in situations where your client, you know, it's clear that he pleaded guilty to something that he didn't do. It does get a little bit trickier, and you of course don't want your client to admit to having done something that he never did do, but you do still want to find a way to work with your client to be able to express that he understands that the actions that he was convicted of, for example, are wrong and not something that he would do in the future. And you want to present witnesses who know your client well. The worst thing that could happen is you have a witness appear in court who turns out to not know anything about your client's criminal record for which he's seeking a waiver. So definitely somebody who knows him well, understands his past mistakes, but also understands how he's able to repair himself in the future would be the best witness. Okay, I know I've taken probably too much time, so I'm going to pass it on to Lupe now. Hold on, Lupe, let me pass the baton back to you.
Hi, everyone. I see a couple more questions that we didn't get to in the chat, in the question box, so we will address those hopefully at the end, but I'll try to incorporate some of Castillo Perez in my presentation as well. Just bear with us while we do the switching and my lack of fluency in technology. All right, so I'm going to start off with non-LPR cancellation. And this is the statutory language for non-LPR cancellation. We're going to go through each of the elements at a time to kind of show you what the pitfalls are there, things to explore with your potential clients. But 4 elements, well 5 for non-LPR cancellation. As Hina mentioned in the beginning, all of the forms of cancellation that we're going to be discussing today are discretionary, so you always want to keep that in mind, even if a client does qualify for non-LPR cancellation, and how you can show that they merit this waiver. So the first element for non-LPR cancellation is that they have been physically present in the United States for 10 years. So thinking of that 10 years and what can stop the time for those 10 years. The service of a notice to appear can stop that time. However, make sure that you're looking at that notice to appear carefully, making sure that they're Pereira-compliant, that they have that time and date at the bottom. Of course, there's that Board of Immigration Appeals that says that that defect is cured with the subsequent notice of a hearing. So really looking at the paperwork, seeing if there's anything that can stop the time for there or what arguments you can make. Prior contact with immigration enforcement. So for example, if someone has left either with a removal order, and they're not put into 40 proceedings, or with a voluntary departure and they are put into 40 proceedings, keeping in mind that that stops the time as well. Any extended absences from the United States, period in excess of 90 days or periods aggregate exceeding the 180 days. I think we try really hard to show that a person has been present within those 90-day increments when we are trying to prove up the case, but it does get pretty difficult with detained clients proving those periods of time. So here's your hypothetical. Things to keep in mind as we're reading this: is Elmo eligible to seek non-LPR cancellation, and what additional information you would need to know? Feel free to use the chat box to answer this hypothetical. So Elmo came to the United States in 2005 to work. Sorry, lots of screens going on that prevent me from reading the full hypothetical, but you all can read it amongst yourselves for those things that are blocking my screen. Is Elmo eligible for non-LPR cancellation? What do folks think? So I'll give people some time to answer that question. Or what are the things that you would want to know to ensure? What are the things that you would want to know to determine if Elmo's eligible? So I see some starts. Yeah, that's exactly right. Elizabeth, Juan Camilo, Rosa, Vanessa. One, did he comply with the voluntary departure order, or did he not comply? When did he leave the country? When was he placed in proceedings? Are proceedings placed in 2020, or were they initiated before? Has anything stopped the time of Elmo, either the date of the NTA or anything further, him leaving the United States? Those are all good questions. So presumably, if Elmo did comply with voluntary departure, came back right away, and has the 10 years, he would be eligible for non-LPR cancellation because he has the presence for the 10 years. All right. So the second element, and I think this is where a lot of the matter of Castillo-Perez questions are going to come into play here. So we have someone who's seeking non-LPR cancellation. They have to have good moral character for those 10 years. So refer back to the INA 101F to show how a person can demonstrate good moral character. And then just keep in mind that there are automatic disqualifications for good moral character, such as being a habitual drunkard, controlled substance violations, with the exception of a marijuana for 30 grams or less, but don't get excited because we still have the third element to go over: prostitution, smuggling, gambling, false testimony for immigration benefits, 180 days, cumulatively in jail for any offense, aggravated felonies, and as some people were pointing out before, that new Board of Immigration Appeals decision of matter of Castillo-Perez says that 2 or more convictions for DUIs presumptively bar an applicant from establishing good moral character. But even though you see those 2 or more DUIs in that 10-year period, we did include in the handouts the clinic practice pointer for how you can overcome that bar. So getting creative in those arguments of are there psych evaluations that we can get for your client to prove why this shouldn't bar them from demonstrating that they have good moral character. So it's not lost, it's just much harder. And then the third element to keep in mind in determining whether someone qualifies for non-LPR cancellation is any conviction under INA 212A2 or 237A2 or A4. So these are some, think back on those inadmissibility, deportability trainings that some of you may have attended before, or the immigration webinar that Diana and I did in the past. CIMTs, controlled substance convictions, the controlled substance trafficker, the prostitution within the 10 years, the aggravated felonies, the firearms offense, the crimes of domestic violence, all those disqualify someone because under the third element, you cannot have those criminal convictions for someone to qualify for non-LPR cancellation. The second element is good moral character. The third element are those criminal conviction bars. The fourth element is exceptional and extremely unusual hardship, and it has to be to a qualifying relative. So it'll be important to distinguish this element from VAWA cancellation, which we will discuss in a little bit. But they have to have a qualifying relative, and those are your USC or LPR spouse, your USC or LPR parent, your USC or LPR child who's under 21. So this is a relatively high standard. And then we have included the two cases that you can refer to for a more in-depth discussion of how that high standard can be met. It is a totality of the circumstances test. So thinking about how you can prove that the hardship is exceptional and extremely unusual, or that is what is normally expected if someone is deported with their family to a less developed country. So how do you prepare a winning 42B case? So it's the same procedure as the 42A that Hina discussed when preparing the application for that for LPR cancellation. And then you do want to prepare a short pre-hearing brief emphasizing hardship. In our experience, this is where it takes a little bit more convincing and explaining and articulating to judges why individuals do meet that hardship standard. And you want to submit documents in support of the application. So thinking back to what things that you're trying to prove that qualify a person for non-LPR cancellation. So thinking about your presence documents, thinking about that criminal chart to demonstrate that they have good moral character and that they don't have any crimes that automatically bar them from non-LPR cancellation. And when it comes to the hardship, thinking about what are the medical and school records if the individual has children to show that they would suffer if they were returned to home country, or what would happen to them if they stayed in the United States and parents were deported. So thinking about both situations, both if family stays in the United States, if the individual is deported, and if that family goes to home country, if the individual is deported, trying to prove both things for that hardship and getting evidence of those two things, evidence of medical treatment, evidence of how your client is needed for that person, for those family members to remain in the United States. For good moral character, rehabilitation if that's needed, always thinking about how family can provide letters of support or affidavits to support each of those elements that a person needs to demonstrate for non-LPR cancellation. And as I mentioned, non-LPR cancellation is discretionary. So going back to what Hina was discussing when preparing that 42A application, what are some merit, what are some discretionary factors that you can throw in there to demonstrate that this person not only qualifies, but merits this form of relief. So we are going to go into a hypothetical. So the first question that we want to answer is Alvin non-LPR cancellation eligible? I don't think you need any statutes for this one, but I'll give you a minute or so to read it and then to use the chat box to determine if Alvin is non-LPR cancellation eligible. So think about those 10 years, think about the good moral character, think about if there are any criminal bars that would prevent him, think about the hardship. Is he eligible? So he does have 3 DUIs. I know someone is mentioning the fact that he does have 3 DUIs, but think about the period of when you need to show good moral character. So if he's in proceedings in 2020, that would be from 2010 to 2020. That 2003 DUI falls out of that 10-year good moral character period. When did he receive the NTA? Let's assume that Alvin received the NTA last week. Oops, sorry. So Alvin is non-LPR cancellation eligible. He does have the physical presence. He has 2 DUIs, but we can explore a little bit more of how he can overcome that presumption. He doesn't have any criminal bars that would bar him from non-LPR cancellation. And it seems to me that he has 2 children that we could explore as advocates what exceptional and unusual hardship they would suffer if he were deported. What if Alvin had a 2005 misdemeanor retail theft for which he completed probation? I'll throw in a crim M wrench in there. Is that a conviction for immigration purposes? What do y'all think? Yes, that is a conviction. So if he does have that conviction, would he be eligible for non-LPR cancellation? So thinking back on those criminal bars, crimes involving moral turpitude under INA 212, and then remembering that petty offense exception. The retail theft, let's say it was Illinois. Yes, it's a misdemeanor and not in jail for more than 180 days. So, what are some equities that you would want to explore and present for Alvin's case? Sorry, y'all. I thought I had uncovered most of the typos, but there's still a typo in there. What equities would you want to thinking about so he still has those DUIs, what as advocates would we need to beef up in his case? Rehabilitation efforts, exactly. Exactly, Jean. The kind of services that kids would need may be difficult to receive in their home country or hard to pay for if he is gone. Exactly, his important role in parenting children. Yep, focusing on rehabilitation. What steps has he taken? If he's like our detained client and hasn't been able to acquire that rehabilitation, what is his willingness to get that rehabilitation? So things that we do in the detention team is we look up AA classes and see which ones are close to home, which ones are in the language that our clients prefer, those kind of things to show rehabilitation. And relationship to his children, exactly. So getting letters from children, getting if they are able, if mom is or dad is in the picture, if they are able to also corroborate that. Exactly. All right. I do want to leave some time for questions, so I'm going to move on to VAWA cancellation. So VAWA cancellation has some of the same elements as non-LPR cancellation. The first one is it's for individuals who have been battered or subjected to extreme cruelty by a USC or LPR parent, but it's also for parents of USC children who have been battered or subjected to extreme cruelty by such citizen parents. So it's both, were they the victim of battery or extreme cruelty, or were their children victims of battery or extreme cruelty? So I think the first element is usually the most evident one, being the victim of any violence or forceful detention. The second element may take a little bit more exploring, so that's why I put that power and control wheel there, because they're trying to see if it fits an overall pattern of violence. And since some of these cases tend to involve domestic violence, thinking of ways of which you can look at your client's situation in a holistic manner to make the argument that they were subjected to extreme cruelty or that their children were subjected to extreme cruelty. So thinking about with your clients, was their immigration status used against them? Were their children used against them to show that extreme cruelty? Those that physical, that verbal, emotional abuse, financial exploitation, all of those things can help you look at that extreme cruelty element. Oh, and then the second element is the nice part about VAWA cancellation is that you only have to show presence for 3 years prior to the application. So it's important to know that the 3 years are not stopped by the notice to appear. So it still keeps running until the application. Good moral character. So think back as on the discussions that we've had for good moral character for non-LPR cancellation and how you can help meet that element. And then the fourth element is not inadmissible or deportable under criminal or security grounds. So think back about separating the good moral character from the criminal bars that would bar someone from VAWA cancellation or non-LPR cancellation. Extreme hardship. So couple of things to flag for you all from non-LPR cancellation is that it is a lower hardship standard than non-LPR cancellation. So you can also bring it in with non-LPR cancellation, but it might not meet that standard. Is those financial hardships that would be in place if someone were deported, the age of the applicant when they entered the United States, the ties that they have in the United States, the lack of ties they have in home country. And I'm mentioning applicant because you can demonstrate hardship to their family in the United States, but you can also demonstrate hardship to the applicant himself or herself as well. So different lower standard, and you can also include the applicant would be the two takeaways for that extreme hardship aspect of that. So preparing a VAWA cancellation case, it's the same application as non-LPR cancellation. So you just check a different box. There's 2 questions and the first page that it would get to this relief. So you just making sure you check the appropriate box or checking both boxes. Prepare a short hearing brief emphasizing the abuse or the extreme cruelty that the person has suffered or that the children have suffered, and hardship. Those are the 2 things that you would want to focus on a VAWA cancellation case. What kind of documents would you want? So going back to the elements of VAWA cancellation, you need to prove that they've been here for 3 years. You need to prove that they have been that they or their children were victims of battery or extreme cruelty. What are some ways that you can prove that? I think someone just asked a question about that. Does there need to be a police report? Not necessarily to demonstrate the extreme cruelty. So a detailed affidavit from your client could be sufficient. Also, any letters of support or affidavits from people who your client discussed the abuse from would be another way to get at that. So no need for a police report. It's helpful if you have it to include it, but it's not a requirement for VAWA cancellation. Pictures, some of the things that we have also included in VAWA cancellation, especially if the extreme cruelty is to the child, are DCS reports detailing the abuse or the reasons why the child was placed in DCS custody, especially if it was not because of your client. And then I see more questions about that. I'll just quickly wrap up VAWA cancellation and then also try to get at those questions as well. Psych evaluations are very helpful. Another way to show that they have been subject to extreme cruelty if they get to a diagnosis of PTSD. That would also enable you to demonstrate that. Affidavits of support, rehab. Again, it's discretionary, so getting all of those, all of that evidence that would show you that they do merit that. Should you try to get a U visa for someone who qualifies for VAWA cancellation? That depends on if you're able to get that police report and if you're able to get that certification from the police that would allow you to continue on with the U visa. The nice thing about VAWA cancellation, though, is that once you win your case, which, as Hina mentioned in the beginning, could be a matter of months in the detained docket, your client is an LPR. No need to wait for that long U visa delay. So. Does DHS often cross-examine a victim about the victimizing or victim blaming? I actually have not seen a lot of victimizing in these cases. We've actually had pretty good luck with judges. I think it comes down to how detailed is that affidavit, because and if you're able to get any other supporting evidence about the extreme cruelty that someone has suffered, because then often judges are like, you've met the first element. Let's talk about the hardship. So let's move on to another hypothetical. So some of the things to keep in mind, is Brian eligible for VAWA cancellation? And also think, is Brian eligible for non-LPR cancellation? And as advocates, which one would you want to flag? Thinking about preserving and applying for all forms of relief that your client is eligible for when thinking about this hypothetical. So he entered in 2010. There's so many screens sometimes. In 2015, he met Carolina at USC. A son in 2016, daughter in 2019. Started using drugs. Started taking the money from rent and bills for drugs. When Brian tried to divorce Carolina, she tried to call ICE on him, insulted, threw things at him. He eventually left. He was then contacted by Child Protective Services because their son was found wandering the street and the children were placed in foster care. He was taken into custody after 2019, and he has a dismissed domestic violence case. Let's say it's from Illinois from 2018. Is Brian eligible for VAWA cancellation? Or what other information would you need to make that determination if he is eligible for VAWA cancellation? I'm just going to go ahead and answer it because we have like 3 minutes on the presentation before. So he is, was he implicated in the DCS case in any ways? Yeah, so you want to find out, one of the things is like, why did he, what are some ways that we can help Brian explain why he left the children with mom? What was his involvement later on? Was he implicated in any way on the DCS case? But if he wasn't, he is eligible for VAWA cancellation. He's also eligible for non-LPR cancellation. So talking to Brian about like, can he show those 10 years or can he only show those 3 years? Those are the types of things that you would want to keep in mind if you're want to concentrate on one over the other, but making sure that you apply for all forms of relief that your client is eligible for is important. What if he was convicted of that domestic battery, would he still be eligible for VAWA cancellation? Yep, that's exactly what you need to determine. Was it insulting or touching versus bodily harm? If it was insulting or touching, he would still be eligible, but if it's bodily harm, he would not be eligible. And then the last question is, how would you prep Brian, or how would you prepare Brian's case? What are some things that you would want to, as an advocate, make sure that you address in your preparation of his case? So you would want to probably prepare, would Brian, what is the hardship that Brian would suffer himself if he were deported, and also trying to get at the hardship that the children would suffer. Would the children go back to Brian? Is Brian in the birth certificate? What are the kind of things, those are the type of things that you would want to also explore with Brian, talking about what was that domestic violence case about, what were the circumstances, even though it was dismissed. Talking about that DUI or other things that you would also want to talk about, and getting Brian a psych evaluation, and hopefully getting DCFS to cooperate with you so that you can get all the relevant documentation for his case. That is what we have for VAWA cancellation, non-LPR cancellation, and LPR cancellation. Any questions that we missed, or any other questions that you all may have?
Yeah, and just to flag, guys, we set this presentation for 12 to 1, so folks need to leave. Feel free, but if folks want to stick around, I think we could probably, you know, we have the GoToWebinar. I can continue on at least for another 10 minutes if folks do have additional questions.
Oh, so in terms of discretion, when a client has non-disqualifying convictions but claims that the conviction resulted from police misconduct, how do you represent, or how do you present remorse or responsibility, assuming post-conviction relief is not possible?
Yeah, I mean, that's a really good question. We see this a lot. And I was trying to get at that quickly before during the LPR cancellation portion, but didn't want to take too much time. But you know, where the person is saying that they didn't actually commit the crime, and but you do believe them, you just want to try to explore ways in which, you know, they can express that the thing that they were accused of doing is something that they believe is wrong and not something that they would do, right? So for example, if someone was convicted of domestic violence and, you know, they're saying, I never did, that wasn't me, I would never hit a woman, you know, I don't believe in that, then, you know, talking to them and seeing if you can, you know, prepare them to testify that, you know, even if they're denying that this happened, first, that they're not denying it in a way that's going to make it sound like it's just excuses, right? So, you know, I think even in a situation where our client says that the police did something wrong, we always discourage them from testifying to that in court, because the judges do tend to side with law enforcement. A lot of them come from the prosecutor background. You know, Judge Roche in Chicago was a police officer. So yeah, we want to discourage clients from pinning the blame on the police, but rather just finding a way to say, I know I was arrested for that, and the police report says this. You know, I did not do it. I believe that domestic violence is wrong. I have seen how my sister has been abused by her husband, and I have tried to help my sister, and I would never want some like anyone else, any other person I know, to be the victim. So that's just an example of just finding another line of questioning and answering, so that it doesn't come off like your client is making excuses or blaming it on somebody else, but it's still, you know, expressing that he knows that that type of behavior is wrong.
Yeah.
I did just want to go back up to, there was a question on the VAWA going back to that VAWA cancellation, hypo, and the domestic violence conviction, and just clarifying that, you know, there is a waiver available if somebody is ineligible for VAWA cancellation and cannot demonstrate good moral character. But if the ground that is destroying eligibility is actually a ground of inadmissibility or a ground of deportability under 212 or 237, that cannot be waived. It's only the good moral character grounds that do not also trigger 212 and 237 that can be waived, right? For example, if you had somebody who could not show good moral character because they served more than 6 months in jail, say because of DUIs that were attached to the abuse, that could be waived because those DUIs aren't going to separately trigger a 212 or 237 ground. But if they've been convicted of a crime of domestic violence themselves, that does trigger removability under 237A2E, that could not be waived even if it was connected to the abuse. And I caught a typo in the PowerPoint when we were on that slide. It said qualifying offense, qualifying instead of disqualifying, but just to clarify that. And then there's one more question here from Jean. The exception for petty offenses. Yeah, so I mean, this question about, you know, what for non-LPR cancellation, is there a petty offense exception for CIMTs but not for marijuana? Really, this is going back to the language of INA 212A2, the criminal grounds of inadmissibility, and what is written into that language. So the 212A2 language itself has a petty offense exception for CIMTs, where if the person has a CIMT that is not punishable by over a year, and they're not sentenced to more than 180 days jail time, that would not make them inadmissible. So that language is written into 212A2. So that's why this petty offense exception for CIMTs can apply even for non-LPR cancellation. But there's no petty offense exception written into 212A2 for the marijuana possession under 30 grams. That exception is only in the 237 grounds. So therefore, the marijuana under 30 grams would still trigger 212A2 and would make somebody ineligible for non-LPR cancellation. Okay, so let's see, we'll give it about 1 more minute if anyone wants to put in any last minute questions. If not, we will sign off. I did want to note that I hopefully successfully uploaded the materials as well into GoToWebinar, and I believe that we were also going to try to email those out. If you don't have the materials already, we will be getting those to you. You may be able to see them at GoToWebinar. And if not, you will have them soon. We'll be providing the PowerPoint as well as a handout with some attachments and citations.
Got one.
Okay, here's one more question. you want to try to tackle this one, Lupe?
Can you all give an example of the lowest level of hardship that you have shown that has met the extreme and unusual hardship standard? ADD cases, or I think there's been one where child suffered from ADHD in school, and that was pretty much the hardship. There was also financial hardship, which usually is not enough. But mom was pretty compelling on the stand about why that is exceptional and extremely unusual hardship, and like describing the close relationship that child had with dad, and about how child has the support system in school, and they have a really good school in the United States, and that mom and child would not go to Mexico. I think that was a while ago, so it might be more challenging now. I think that's the one that where I think would be borderline.
Yeah. Yeah, and I think that, I mean, the other thing I would add is when you have cases where there's like multiple kids, for example, and there's a good range of ages, where the older ones are teenagers and the younger ones are infants or toddlers, and they're all totally Americanized. You know, it was a while ago as well, but I was able to prevail in a case where there, weren't really significant medical needs, but it was this all-American family with kids ranging in ages, and there were 4 of them, and yeah, it was just clear that they wouldn't have the same opportunities in Mexico as they have here. Again, everything's getting a little bit tougher these days, but where there are positive factors and it's a close-knit family, and it's really clear that your client is important to his kids, it can be worth trying, and sometimes you'll prevail. Okay, so I think we'll sign off there. Thank you so much, everyone, for joining. Sorry about some of the technical difficulties as we learn to navigate this platform. Please remember that we have another webinar coming up on May 15th. Lupe will be back for that one along with Diana Rashid, and they will be talking about doing bond hearings in immigration courts.
And there will be an evaluation going out.
Yeah, we'll be sitting on an evaluation, and yeah, we much appreciate folks doing that. We are requesting CLE for this, and so I do need to have an evaluation process, and also love to get feedback so we know how to improve our presentations down the line as well. All right, we're going to end the presentation. Thanks, everyone.